The family. Concept of family. Article 149 of the Family Code. The family, being the foundation of the nation, is a basic social institution which public policy cherishes and protects. Consequently, family relations are governed by law, and no custom, practice, or agreement destructive of the family shall be recognized or given effect. Article 150 of the Family Code. Family relations include those: 1. Between husband and wife. 2. Between parents and children. 3. Among other ascendants and descendants. And 4. Among brothers and sisters, full or half blood. Family is an institution that is governed by the law. The internal aspect of the family is sacred and inaccessible to law because law must respect the freedom of action of men. Effects of legal disputes. Article 151 of the Family Code. No suit between members of the same family shall prosper unless it should appear from the verified complaint or petition that earnest efforts towards a compromise has been made, but that the same has failed. If it is shown that no such efforts were made or were in fact made, the case must be dismissed. General rule: no suit between the members of the family shall prosper, except when suits between members of the family shall prosper only if it shall appear that a verified complaint or petition that a. Earnest efforts towards a compromise have been made, b. Such efforts have failed, and c. Such earnest efforts and the fact of failure must be alleged. The case will be dismissed if it is shown that no such efforts were made. Article 151. Exception to the exception. A verified complaint or petition is not needed for matters not subject to compromise. Under Article 2035 of the Civil Code, the following cannot be subject of compromise: 1. Civil status of persons. 2. Validity of marriage or a legal separation. 3. Any ground for legal separation. 4. Future support, as it is presumed to be needed for the survival of one of the receiving one receiving support. And 5. Jurisdiction of courts. 6. Future legitimate. Take note that in case of doubt, all presumptions favor the solidarity of the family. Article 220 of the Civil Code. Article 151 of the Family Code only applies when the case is exclusively among members or among family members. Whenever a stranger is included as a party to the case, Article 151 does not apply. The case of Hontiveros versus RTC, 1999. Suits between brothers-in-law can prosper even without a verified complaint or petition. Guerrero versus RTC, 1994. The enumeration of brothers and sisters as members of the family does not comprehend sisters-in-law and brothers-in-law. Gayon versus Gayon, 1917. Family home. What constitutes the family home? The family home is a dwelling house where family resides and the land on which it is sustained. Article 152. Limitations on the family home. The family home must be part of the properties of the absolute community or the conjugal partnership, or of the exclusive properties of either spouse with the other's consent. It may also be constituted by an unmarried head of a family in his or her own property. Article 156. The actual value of the family home shall not exceed, at the time of its constitution, the amount of 300,000 pesos in urban cities and 200,000 pesos in rural areas, or such amounts as may hereafter be fixed by law. Article 157 of the Family Code. A person may contribute and be the beneficiary of only one home. Article 161. Who may constitute the family home? The family home may be constituted by A. Jointly by the husband and wife, or B. An unmarried head of the family. Article 152. Take note that a person may constitute and be the beneficiary of only one family home. Beneficiaries of the family home: A. The husband and wife, or an unmarried person who is the head of the family, and 2. Their parents, descendants, brothers and sisters with their relationship may be legitimate or illegitimate who are living in the family home and who depend on the head of the family for support. Article 154. Requisites to be a beneficiary of the family home. A. The relationship is within those enumerated in Article 150 of the Family Code. B. They live in the family home. And C. They are dependent for legal support on the head of the family. Occupancy of a family home must be actual in order for one to be a beneficiary. Actual occupancy need not be the owner of the house specifically. Rather, the property may be occupied by beneficiaries enumerated under Article 154, which may include the in-laws or the family home is constituted jointly by the husband and wife. But the law definitely includes maids and overseers. But the law definitely excludes maids and overseers. They are not beneficiaries contemplated in the code. Patricia versus Dario, 2006. The term descendants contemplates all descendants of the person or persons who constitute the family home without distinction. Hence, it must necessarily include the grandchildren and great-grandchildren of the houses of the spouses who constitute the family home. However, descendants cannot be considered beneficiaries if they are supported by their own parents and not by the ascendants who constituted the family home. When deemed instituted, the family home is deemed constituted on a house and lot from the time it is occupied as a family home. Article 153 of the Family Code. Exemption from forced sale, execution, and attachment. Generally, the family home is exempt from the following from the time of its constitution and so long as any of its beneficiaries actually reside therein. 1. Execution. 2. Forced sale. And 3. Attachment. Under Article 153. Exceptions in the exemption of the family home for execution. 1. Non-payment of taxes. 2. Debts incurred prior to the constitution of the family home. 3. Debts secured by mortgages on the premises before or after such constitution. And 4. Debts due to the laborers, mechanics, architects, builders, material men, and others who have rendered service or furnished material for the construction of the building. Article 155. Claims not among those in Article 155. When a creditor whose claim is not among those mentioned in Article 155 obtains a judgment in his favor, and he has reasonable grounds to believe that the family home is actually worth more than the maximum amount fixed in Article 157, he may apply to the court which rendered the judgment for an order directing the sale of the property under execution. Article 160, paragraph 1 of the Family Code. To warrant the execution of sale of the family home under 160, the following facts need to be established. 1. That there was an increase in actual value. 2. The increase resulted from voluntary improvements. And 3. The increase in the actual value preceded or exceeded the maximum limit allowed by Article 153. The case of Eulogio versus Bell, 2015. The actual value of the family home shall not exceed at the time of its constitution the amount of 300,000 in urban areas and 200,000 pesos in rural areas, or such amounts as may be thereafter be fixed by law. In any event, if the value of the currency changes after the adoption of this code, the value must favor the constitution of the family home. The value most favorable for the constitution of the family home shall be the basis of evaluation. Urban areas include chartered cities and municipalities. All others are deemed to be rural areas. Article 157. Procedure to avail of right under Article 160. 1. The creditor must file a motion in court proceeding where he obtained a favorable decision for a writ of execution against the family home. 2. There will be a hearing on the motion where the creditor must prove that the actual value of the family home exceeds the maximum amount fixed by the Family Code, either at the time of its constitution or as a result of the improvements introduced thereafter. 3. The creditor proves that the actual value exceeds the maximum amount. The court will order its sale and execution. And D. If the family home is sold for more than the value allowed, the proceeds shall be applied as follows. 1. First, the obligation enumerated under Article 157 must be paid. 2. when the judgment in favor of the creditor will be paid plus all the cost of execution, and 3. The excess, if any, shall be delivered to the judgment debtor. Generally, the proof that the house is the family home must be alleged against creditors. Applied the rule in Article 160 of the Family Code, Versola versus Mandularia, 2006. Take note that the provisions of this code shall also govern existing family residences insofar as provisions are applicable. When the family home may be sold, the family home may be sold, alienated, donated, assigned, or encumbered by the owner or owners thereof, when or with the written consent of the person constituting the same, the latter spouse, and the majority of the beneficiaries of legal age. In case of conflict, the court shall decide. Article 158 of the Family Code. Requirements for the sale, alienation, donation, assignment, or encumbrance of the family home. A written consent of the following. 1. The person constituting it. 2. The spouse of the person constituting it. And 3. The majority of the beneficiaries who are of legal age. Article 158. When terminated, the family home shall continue despite the death of one or both of the spouses or of the unmarried head of the family. A. For a period of 10 years, or B. For as long as there is a minor beneficiary, and the heirs cannot petition the same unless the court finds compelling reasons therefor. The rule shall apply regardless of whoever owns the property or constituted the family home. Article 159 imposes the proscription against the immediate partition of the family home, regardless of its ownership. This signifies that even if the family home has passed by succession to the co-owners of the heirs, or to the co-ownership of the heirs, or has been willed to any one of them, this fact alone cannot transform the family home into an ordinary property, much less dispel the protection cast upon it by the law. The rights of the individual co-owner or owner of the family cannot subjugate the rights granted under Article 159 to the beneficiaries of the family. The case of Ariola versus Ariola, 2008.